Hi class, this is the lecture on the death penalty or capital punishment as it is often called. In this lecture we're going to talk about more sociology and criminal justice than we are psychology. But we're going to talk about the evolution of the death penalty in modern jurisprudence. We're going to talk about some of the statistics around the death penalty. And we're going to talk about whether or not it's an effective deterrent. We're also going to talk about something called death qualification, which is a psychological concept. There was it's a legal concept, but it was the focus of quite a bit of psychological research in the 1980s and the 1990s, and we'll talk about some of that as well. I'm going to try to stay away from some of the moral arguments around the death penalty. I think that there are good moral arguments against the death penalty. I also think that there are some good moral arguments for the death penalty. So we're really going to stay away from that. Ultimately, you have to decide if you're in favor of capital punishment or not, but at the very least, you should understand the system and how it works and what its flaws are. So what you see on the slide in front of you, of course, is two methods of execution, two of the more popular methods in the United States, the electric chair and the table there where they subject inmates to lethal injection. Pretty gruesome stuff. So we're going to start by taking a trip back in time to 1972. So around 1972, there was a challenge before the Supreme Court, and the case is called Furman versus Georgia, and you should know the name of that case. But this was a landmark case that challenged the constitutionality of the death penalty. So up until 1972, the death penalty was legal in the United States. And so Furman versus Georgia, the defendants in this case argued that capital cases resulted in arbitrary and capricious sentencing. Arbitrary and capricious, those two words together are very famous in American law. Basically what that meant was that the death penalty was not applied consistently. It was kind of a toss-up in terms of who got the death penalty and who didn't get the death penalty. So some people would get the death penalty for a murder, and other people would not get the death penalty for a similar murder. In addition, there were there's plenty of evidence for racial discrepancies in sentencing. In any case, the argument was that the death penalty, because of its arbitrary and capricious nature, was cruel and unusual punishment under the Eighth Amendment, and it was also, argued against the Equal Protection Clause. So basically, for a law to be valid, it has to be applied consistently. It has to apply to everybody. We don't have a society where some laws apply to some people some of the time, and other people other parts of the time, at least not officially. So that was the argument in Furman versus Georgia. So the Supreme Court looked at the evidence and ruled in favor of the defendants. And what happened is the Supreme Court effectively voided 40 death penalty statutes throughout the country. So at the time, there were about 40 states that had the death penalty and 10 states that didn't. And basically, all of the death penalty laws in the United States were voided. And basically, the Supreme Court said, as your laws exist now and are currently carried out, they are unconstitutional because they are, again, being carried out in an arbitrary and capricious manner. So this effectively voided all the death penalty statutes in the United States, and it commuted the sentences of all the death row inmates around the country, and they were given life in prison without parole. Again, it's effectively outlawed the death penalty in the United States. And so basically the Supreme Court said you need to come up with a new system for administering the death penalty, one that's fair and one that acts consistently. And so the states kind of went back to the drawing board and came up with a new system called guided discretion, and that was challenged before the Supreme Court in 1976. in a case called Gregg versus Georgia, which is also a case that you need to be familiar with. And basically what this did was it limited the discretion by providing sentencing guidelines for the judge and jury. So here the states eventually came up with guidelines for whether or not to hand down a death sentence. And within these guidelines, they allowed for the introduction of what's called aggravating and mitigating factors in determining whether or not someone should be sentenced to death. And I'll talk about aggravating and mitigating factors in a minute. And it effectively reinstated the death penalty for states with guided discretion statutes. So essentially, states that got on board and adopted this new model in these sentencing reforms, the death penalty was again found to be constitutional. So in addition to guided discretion, there were 3 additional changes to death penalty laws in the United States. First, the trials were bifurcated, which means that the penalty phase and the sentencing phase were separated. So now the way that death penalty trials work is there's a trial phase, and in the trial phase, it is determined whether or not the person is guilty or innocent. If they are found innocent, the person is obviously free to go, or I should say, if they're found to be not guilty, they are free to go. If they are found guilty, there's a separate second trial, mini trial, as it were, to determine whether or not the person should get life in prison or should be sentenced to death. So in this second sentencing phase, the second phase of the trial, the question is not about guilt or innocence. The question is whether the person should live or die, and that's where aggravating and mitigating factors are presented, which we're going to talk about next. In addition to the trials being bifurcated, there's an automatic appellate review of convictions and sentence, and there's a proportionality review. So let's talk about the appellate review for a second. The role of the appellate courts in the justice system, what happens is when you appeal a verdict, the appellate court, they don't hear trial arguments. They don't hear from the attorney, the prosecution, or the defense. It's not like there are rarely oral arguments in appellate cases. What happens is that the two sides, the defense usually submits a petition. It's not always the defense. Sometimes it's the prosecution. But they submit a petition, and basically what happens is the appellate court reviews the case to make sure that the law was followed in the trial. Now, they're not looking to determine whether or not they think the person was wrongfully convicted or should have been convicted even though they were found not guilty. That's not the role of the appellate court. The role is to determine whether or not the law was followed, whether or not the judge allowed certain evidence in correctly, or so on and so forth, right? There's a many number of issues the appellate court might look at. It's not enough that the appellate court finds that there was error in your case. That's not going to overturn your verdict and get you a new trial. There's something called the harmless error rule, and basically, if the court finds that there was a mistake made in your trial, but they believe that if the mistake had been corrected, the outcome of the case would have been the same, you're not going to get a new trial. So they will only give you a new trial if they believe that the error was substantial and, had it been corrected, would have led to a different outcome. And then the proportionality review is there's a review of the crime and the circumstances to make sure that the death penalty in this case is consistent with similar cases under similar circumstances. So let's talk about guided discretion and how that kind of works in a bifurcated trial. So I just got done saying that there are 2 parts of the death penalty trial. There's the trial phase and the penalty phase. So if someone is found guilty of capital murder, the defense, the penalty phase is about whether or not they should live or die, right? The defendant should live or die. And to make their arguments, the defense is going to present what are called mitigators or mitigating factors, and the prosecution is going to present what are called aggravating factors. And in order to recommend death, the jury must find that the aggravators outweigh the mitigators to impose the death penalty. So basically, mitigating factors are reasons why you should not get the death penalty, and aggravators are factors that argue for the death penalty for the defendant. So when we talk about mitigating factors, this is again, that's what the term mitigate means. It means lessen. So these are reasons arguing why you should not get the death penalty, and the prosecution presents aggravators arguing for the death penalty. So let's talk about some of the mitigators. And again, mitigators are factors that temper or moderate the punishment. And what mitigators can be presented at trial? Well, the defense can present anything really. Any factors they believe are mitigating can be presented during the penalty phase. So, for example, when the murder was committed or the crime was committed, was the defendant under duress? Were they under coercion? Were they acting under extreme emotion? Do they have a psychological impairment or mental illness? And actually, it says mental retardation there. And actually, the Supreme Court, not that long ago, has ruled that it's unconstitutional to execute the mentally retarded people of a certain IQ or who are mentally incapacitated. Does the defendant have a history of abuse? What's their age? Were they really young? Did they have a prior record? These are all potential mitigating factors. In terms of aggravators again are factors that argue for punishment. And they are typically mandated by the state, which means that they're built into the state statute. So in a state that has a death penalty, for example, there'll be a list of 15 or 20 potential aggravators. And the prosecution has to stick to that list. They include the age of the victim. Did the defendant murder a child? The victim's status. Was the victim a police officer? That will is a special circumstance that would, you kill a public official in the line of duty. That's not good for the defendant. Prior record. Is there a history of violence? Was torture involved? Was it a murder for hire? So a murder for hire, basically first-degree murder involves premeditation. So any type of crime, any murder involving premeditation, that's called first-degree murder, or that's a capital crime. So murder for hire, a contract killing, if you intended to kill somebody, if you planned it, that's will make you eligible for the death penalty. And the felony murder rule, which is called murder in the commission of another crime. So if someone dies in the commission of another crime, a felony, that will make you eligible for the death penalty, even if the crime was not premeditated. So if you rob a liquor store and the person behind the counter has a heart attack and dies, guess what? You're on the hook for murder. And in states that have the death penalty, that'll make you eligible for the death penalty. That's called the felony murder rule. So again, those are aggravating factors and mitigating factors, and that's kind of the way the death penalty works. If during the penalty phase, the jury finds that the aggravating factors outweigh the mitigating factors, they're supposed to recommend a sentence of death. All right, so let's talk about the death penalty in the United States, and we're going to talk about some of the statistics. And first, I'm just going to show you some slide with some figures. This just shows you the number of executions since 1976. There have been 1,440 executions between 1976 and 2016. If you look at death row by year, this goes to 2012, and as of right now, there are just under 3,000 people on death row, and the number of people on death row and the number of death sentences handed out has been declining in recent years, but certainly there was a big spike in death sentences right around, which kind of peaked around the late 1990s. Which is when politicians were really getting tough on crime. But this gives you an estimate of how many people are currently on death row by year. Here is another kind of figure to show you death row by year. 1976, there were 420, and 2016, there were 2,905. And it looks like the high point was right around the year 2000, where there were 3,593 people on death row. One of the issues with death row, one of the more controversial issues, is race. African Americans make up about somewhere around 15 to 18% of the American population. But if you look at death row by race, they are overrepresented on death row, making up 42% of death row inmates. So this shows you that there is a racial disparity. Now, it's not to say that the black individuals who are on death row, it's not to say that they're innocent or that they don't deserve the death penalty. What it does say is that the number of black Americans who are sentenced to death row is disproportionate to their representation in society. They are overrepresented on death row, which speaks to racial bias. So there's unquestionably a racial disparity in capital sentencing. Now, one of the other issues surrounding the death penalty is that it's simply flawed. It's a flawed system. It's not a very effective system. And to speaking to that issue, I want to draw your attention to a study that was conducted by a professor at Columbia Law School, Joseph Liebman. And what his research team did was they examined every capital conviction from 1973 to 1995. And so they reviewed approximately 5,500 capital decisions. And what they found was the overall rate of prejudicial error was 68%. So prejudicial error, those are cases where there were errors in the trial record that were so severe that they warranted a reversal of conviction and a new trial. So again, 68%. In other words, the courts found serious reversible error in nearly 7 out of 10 of the capital cases that were reviewed. Okay, so that tells you that the failure rate of the capital justice system is around 70%. For every 10 convictions, 70% are overturned because, and the defendants are given a new trial because there are serious problems with the trial. And if you look at the nature of those problems, of those cases where the court found serious reversible error, 37% involved egregiously incompetent defense attorneys, right? So the defense attorneys failed to call key witnesses, things like that. Number 2, faulty jury instructions to jurors. And number 3, prosecutorial misconduct, often involving the suppression of exculpatory evidence. And exculpatory evidence is evidence that points to a defendant's innocence. So what you need to know for the exam is that about 7 out of 10 death penalty cases are returned on or result in serious reversible error, and these are the 3 leading problems in death penalty cases in this order. Other findings by Liebman's team, of the people who were given new trials, 82% were given a sentence other than death, and 7% were found to be not guilty. So in other words, again, 70% of death penalty cases are overturned on serious error, and the defendants are given a new trial. Of those defendants who are given a new trial, 82% get life in prison, and 7% are found not guilty. All right, so what this really says is that, and by the way, catching so many of these errors, the average amount of time that people spend on death row is something like 9 to 11 years. And that's how long it takes to execute somebody. And so what this really says is that the capital system is really broken. I mean, who designs the system where the failure rate is 70%? Now, I'm not necessarily arguing the death penalty should be abolished altogether, but certainly the system needs to be reformed. If you're going to have the death penalty, it needs to be more fair and more effective. And, I'm not trying to make a pun here, but the system needs to be better executed by the state. One of the other issues around the death penalty is, does the death penalty deter crime? And of course, that is one of the major arguments for the death penalty, is that it deters crime. It deters other people from committing a similar crime. And that's an empirical question. Does the death penalty deter crime? And the evidence seems to indicate no, it does not. So a report by the National Research Council stated that studies claiming the death penalty has a deterrent effect on murder rates are fundamentally flawed and should not be used when making policy decisions. And according to a survey of the former and present presidents of the county's top academic criminological societies, 80% of the experts rejected the notion the death penalty acts as a deterrent. So most of the experts believe that the death penalty does not deter violent crime, right? So, and also the murder rates, if you look at the murder rates per capita, per 100,000 people, which is the figure on the right here of your screen. What that means that in the South, which are very pro-death penalty, Georgia, Florida, Texas, Alabama, Mississippi, these states that are responsible for most of the death sentences in the United States have a higher murder rate than regions that don't have the death penalty. And the way you read that number is, for every 100,000 people in the population, there are 6.7 murders in the South. And for every 100 people in the population in the Midwest, there are 5.3 murders, so on and so forth. What this demonstrates is that the per capita murder rate is higher in states that have the death penalty than in states that do not have the death penalty. And this speaks to the argument that the death penalty does not deter violent crime. And this, again, is some older statistics on murder rates per capita between death penalty states and non-death penalty states throughout the years. Another issue involving the death penalty is that it is very, very expensive. And that is particularly problematic now that you know the presidential error rate. You know that it fails 70% of the time. There have been a number of studies, and these are just some of them here. Defense costs for death penalty trials in Kansas averaged about $400,000 per case, compared to $100,000 in murder cases where the death penalty was not sought, so on and so forth. It says here, the last bullet point, in Maryland, an average death penalty case resulting in a death sentence costs approximately $3 million. The eventual cost to Maryland taxpayers for cases pursued between 1978 and 1999 will be $186 million, resulting in 5 executions within that time period. So again, from just a purely dollars and cents financial perspective, the death penalty doesn't make sense. It's very, very expensive. Here are some additional statistics. Enforcing the death penalty costs Florida $51 million a year, above what would it cost to punish all the first-degree murders with life in prison without parole. So there's no question that the death penalty costs a lot of money, over and above what it would cost to send someone to prison to life without parole. Again, we talked about racial disparity earlier, but we had mentioned that Black Americans were overrepresented on death row. One of the other areas of racial disparity involves the race of the victims versus the race of the defendants. So what we find here is that if you look at the race of the defendants executed, the figure on the left, in most of the capital cases that result in execution, most of the victims are white. And if you look at the race, on the right side, look at the race of the victims in death penalty cases. Most of the victims are white. So what that means is you're more likely to be sentenced to death if you murder a white person compared to if you murder a black person. And that is especially true if you are a black person who murders a white person. Okay? If you're a white person who murders a black person, you're less likely to get the death penalty than a black person who murders a white person. What all of this points to, especially this figure that you're more likely to get the death penalty if you murder a white person, what all of this suggests is that the capital justice system, the criminal justice system in the United States, puts a premium on the life of white people, and essentially means that white people, their lives are worth more, are more valued than the lives of black people. And of course we know that that's absolutely not true, and that's a ridiculous notion. But if you look at the numbers on death row here, that's the implication. That's the implicit implication. That is where you're going to find the racial disparity in the capital justice system. There is no question there is racial bias in the capital justice system. There's racial bias in the justice system as well, but it's very evident in the capital system. Interracial murders, this is more data on interracial murders. Again, white defendant, black victim. There have been 20 executions. I'm not sure what the time period is. And then if you're a black defendant who murders a white victim, holy moly, you are in trouble, right? 282 people have been executed in interracial murders if you're black and your victim's white. All right, so that speaks to some of the racial disparity, the cost regarding the death penalty, the effect of the death penalty as a deterrent, and some of the racial disparity in sentencing and execution. And again, I'm not getting into the moral issue here of the death penalty and if it's morally correct and should we have it or not. But if you're looking at it from a very practical perspective, is it a deterrent? No. Is it fair? Is it equitable? No. And it also costs society a lot of money. So again, my argument would be, without getting into the morality, if you're going to have the death penalty, obviously some pretty serious reforms are in order in order to justify its expense and its cost to society. And also, it needs to be fair. One of the final things I want to talk about is something called death qualification. And again, I mentioned this has been an area of psychological research. And basically what happens in death penalty cases is when they are selecting a jury to serve on in a capital case, during the jury selection process, which is called voir dire, that's jury selection is called voir dire, that's the French term for it. They ask the potential jurors, are you in favor of the death penalty? Are you opposed to capital punishment? And they ask, if the person is convicted in this crime, would you consider the death penalty? Do you have any moral objections to the death penalty? And basically, if you're being considered for a capital jury and you tell tell the court during jury selection, yes, I'm opposed to the death penalty, I am not in favor of the death penalty, I have a moral objection to the death penalty, you are not going to serve on the capital jury. You're going to be dismissed. And from a legal perspective, that makes sense because if the law requires you to consider a capital verdict and you're unwilling to do so, then you shouldn't serve on the jury. It's pretty, black and white as far as the law is concerned. One of the problems, though, is that people who are in favor of the death penalty, and these are the people who are actually going to serve on the jury, tend to be more conservative and have different views about crime and punishment than people who are opposed to the death penalty. And what that means is that your death penalty verdict is going to be, your death penalty, your capital jury is going to be more conservative. And the findings indicate that all things being equal, a jury that's composed of death qualified jurors compared to a jury that is composed of a mixture of people who are in favor and not in favor of the death penalty, your death qualified jury is going to be more likely to convict during the penalty phase. During the trial phase. So, in other words, what this means is that when you go through this process of death qualification, you're really homogenizing the jury, and you're left with a group of people that is, in principle, in favor of the death penalty. And as a whole, they're going to be a more conservative group of people, and they're more likely to convict the defendant in the first place compared to a jury where there are differing opinions about, crime and punishment. And that is called... that is the research on death qualification. Now, the Supreme Court, again, this is a very active area of psychology and law for a number of years, and there were a number of studies demonstrating kind of this inherent bias in death qualified juries. And just what I described, they're more conservative. The Supreme Court ruled that it doesn't matter. Too bad. We're not going to change the law. Death qualification is a constitutional process, and that effectively ended that area of research in psychology and law. All right. So that is all there is on this lecture. There is some reading posted for you on Canvas. Make sure you do that. And I hope you enjoyed this lecture and it gave you some things to think about. If you're interested in learning more about the death penalty, there's a great website called the Death Penalty Information Center, and it is a very anti-death penalty website. There's no question. But they have a lot of good empirical data supporting their position. There is no equivalent for a pro-death penalty website. The pro-death penalty people don't have a lot of empirical evidence that it's cost-effective, or that it's a deterrent, or that there's no racial disparity. They're really arguing out of the issue of retribution, is that there are some crimes that just absolutely demand that the society end the life of the defendant. In any case, something to think about, and I hope you enjoyed this lecture, and that will be it for today.